Let's continue now with our next speaker. Our next speaker is Vassiliki Koumpli. She's an Athens-based Supreme Court lawyer, mediator, and mediation, as well as arbitrator, fellow of the Chartered Institute of Arbitrators. She has studied law in Athens and London and has been extensively trained in negotiation, mediation, and arbitration by renowned institutions such as CRB, CDR, Harvard, Kennedy School. She accepts appointments as mediator and arbitrator, being listed in the rosters held by the leading service providers, including the EU Commission Directorate General for Trade panel of arbitrators. Apart from her activity as third neutral in ADR processes, she is also a senior associate at Watson Farley Williams, advising corporate clients concerning a range of energy projects on all aspects of the applicable energy regulatory framework, as well as EU law, competition law, environmental and climate change laws and regulations. Vassiliki will be speaking specifically about the ICJ Advisory Opinion on climate change, which will give us a new lens for energy investment arbitration. This opinion does represent a pivotal development in the not only EU but also international legal landscape, signaling a more clear articulation of the state's climate obligations and also their interplay with investment protection standards. Vassiliki, the floor is yours.
Thank you very much, Mary. It seems that I cannot see my presentation. Now it's here. So good afternoon to all. It is really my good pleasure and honor to participate in the Athens Conference on European Energy Law and Policy for the fifth consecutive time. And I'm more than grateful to both Professor Antonis Metaxas and Professor Mary Mitzi for this kind invitation and my inclusion in this very, very interesting panel. I will repeat once again that the conference has established itself as an important event hosted by the Hellenic Energy Regulation Institute, which also this year is joined by renowned institutions such as the German Institute für Energie- und Regulierungsrecht, the University of Bergen, and Queen Mary University of London. As highlighted also in earlier sessions today, the global community is confronting an energy transition marked by urgency. This transition is not only political and technological, it also presents profound legal challenges, particularly within the sphere of international investment law. Less than 6 months ago, it was on 23 July 2025, the legal landscape shifted. The International Court of Justice, which is the world's highest judicial authority, issued a unanimous advisory opinion on the obligations of states in respect of climate change. So my presentation today examines its potential transformative development and its implications for the evolving architecture of energy investment law and arbitration. The central question is this, in my opinion: will the ICJ Advisory Opinion generate a new authoritative legal framework capable of reshaping the risk calculus for governments and investors in energy-related disputes? So my opinion is that it very likely will. The opinion has the potential to operate as a new interpretive lens, offering judicial clarity on states' climate-related obligations, clarity that is bound to permeate core concepts in energy investment arbitration. So I will begin with the advisory opinion itself, then turn to the current energy investment arbitration landscape, and finally examine the pathways through which such an opinion can drive systemic change. It was in 2019 when a group of students from the University of the South Pacific in Fiji launched an initiative urging Pacific Island governments to bring the issue of climate change before the International Court of Justice. And their efforts were taken up decisively by the state of Vanuatu, which in 2022, through its permanent mission to the United Nations, convened a coalition of states to draft a UN General Assembly resolution requesting an ICJ advisory opinion. In March 2023, the General Assembly adopted a resolution by consensus, in essence asking the court to clarify two overarching issues. First, the obligation of states under international law to protect the climate system for present and future generations. And second, the legal consequences for states whose acts or omissions have caused significant climate-related harm, and particularly harm suffered by small island developing states and by affected peoples and individuals. The advisory opinion issued by the ICJ on 23 July 2025 is remarkable for two reasons. Its unanimity among the 15 judges and the unprecedented global participation. The court did not mince words, explicitly defining climate change as an urgent and existential threat. This is no longer a political statement, it is a judicial finding of fact based on the best available science. This elevation of urgency from policy to law can be the first element of our new lens, and it establishes that the justification for climate action is no longer discretionary, but mandatory. Although the ICJ advisory opinion is formally non-binding, the court is the United Nations principal judicial organ, and its interpretations of international law carry considerable weight. So advisory opinions are routinely treated as authoritative guidance and often shape both state practice and the evolution of international law. So it is precisely this persuasive authority that makes the opinion so consequential. The opinion's key holdings amount to concrete legal ammunition, we would say. First, the court formally endorsed the 1.5 degrees Celsius temperature limit as the legal benchmark against which all national climate policies must be assessed. Second, it imposed a stringent due diligence obligation, making clear to states that they must actively regulate corporate actors within their jurisdiction to reduce emissions. Inaction itself may now constitute a breach. For energy investors, the most consequential finding is this. The ICJ explicitly stated that measures such as issuing new fossil fuel exploration licensing or granting subsidies may amount to an internationally wrongful act. So this is an unmistakable legal warning and identification of the danger zone for investors. This point is of particular importance for Greece, which continues to support the hydrocarbon extraction program in the sea located south of Crete, a program that was launched in another, now obsolete era before the conclusion of the Paris Agreement. Finally, the court confirmed that violations of these obligations can trigger state responsibility, including reparation. This alone carries profound implications for future damages claims and the broader risk landscape in energy investment. Energy disputes are the largest sector in investor-state dispute settlement. And very often they are directed over state-led energy transition measures, for instance, cancelling fossil fuel licenses, banning extraction or phasing out subsidies. Indeed, we are in an era of so-called green loss disputes where investors in high-carbon assets sue governments for regulatory changes. As states implement necessary transition policies, fossil fuel investors sue under investment treaties. And the result is the well-documented phenomenon of regulatory chill, where the risk of massive compensation demands deters governments from taking the urgent stringent action the ICJ now says is legally required. The battle lines are drawn over two main claims. First, fair and equitable treatment, which is breached when a government frustrates a legitimate expectation of a stable regulatory framework. And second, indirect expropriation, which concerns whether a regulation has completely stripped the investment of its economic value. Arbitral tribunals have traditionally treated climate or environmental concerns as part of the state's police power, a legitimate, non-compensable regulatory right. Tribunals lack the consistent, authoritative standard to weigh the necessity of climate action against the forcibility of regulatory change, namely a state's urgent climate obligation against an investor's commercial expectation. And arbitral tribunals assess regulatory measures using a proportionality test, balancing the public purpose of the measure against the investor's harm. But there has been no definitive international standard, judicial standard. And so the assessment of the weight of that public purpose has been essentially subjective. The new lens can provide a potent shield against fair and equitable treatment claims. A state facing a lawsuit for cancelling a fossil fuel license can cite the opinion, arguing its action was a legally mandated requirement to protect the climate and human rights as articulated by the ICJ. This makes the action inherently non-arbitrary. The most powerful effect is, however, on new investments. The ICJ's explicit ruling about the wrongfulness of supporting fossil fuels means that a prudent investor simply cannot claim to have been surprised by a state when that state shuts down that activity. The threshold for what constitutes legitimate expectation has been raised now on significantly. Furthermore, with respect to indirect expropriation claims, the opinion provides the legal basis to argue that climate regulations are always proportional. When a state acts to prevent an existential threat, the regulation is not disproportionate. The ICJ's reasoning suggests that arbitral tribunals must interpret investment treaties in light of these stringent climate obligations. And this means that investment treaty must bend to accommodate to states' international law duty, minimizing thus the finding of an uncompensated taking in the framework of expropriation. The opinion's finding on state responsibility for not acting, namely the duty to make reparation, is now another counterweight to the investor's claim for compensation. So we notice that the ICJ Advisory Opinion tends to create legal certainty where there was only political ambiguity in the past. For governments, it is an unequivocal shield. For arbitrators, it is a non-negotiable legal precedent they must judicially notice and apply. And for investors, it is a clear warning that the era of relying on investment treaties to safeguard high carbon profits against essential state regulation is over. And indeed, the opinion represents also a structural reformation of the legal risk matrix, which constitutes also an immediate notice to the entire financial community. Any investor putting new capital into coal, oil, or even maybe gas assets, or seeking to expand existing ones, does so in the full knowledge that these activities have been designated as potentially contributing to an internationally wrongful act. In this sense, by raising the legal risk premium, the opinion is also a powerful tool for shifting global capital away from high carbon assets. Summing up, the ICJ's unanimous opinion has redefined the legal hierarchy. It transformed climate change from a policy choice into a binding legal obligation. In the context of energy investment arbitrator in particular, this may act as a new lens that heavily favors the legitimacy and the necessity of the state's climate action, making it substantially harder for carbon-intensive investors to successfully sue for compensation. It remains to be seen in practice whether and how this will signify the end of regulatory chill era. And having said that, I would like to pass the floor back to our moderator. I thank you very much for your attention and welcome any questions.
Thank you. Thank you very much, Vassiliki. That was a very interesting presentation, especially when it comes to investment arbitration. There will always be this tension between the interests of the investor, especially with regards to breaches and protection against expropriation, and then the right of the state to regulate and avoid the so-called regulatory chills. Of course, the new generation of treaties outside the EU, I would say mostly, do tend to respect the sovereign right of the state to regulate, which, even though it is taken as a given, it has to be now underlined in international treaties as a defense against the protection of the investor. So the EU has many interesting views when it comes to investment arbitration. So thank you very much for presenting this perspective.
I decided to not touch this aspect of investment arbitration. So yes, thank you.
Thank you.